Welcome back to Radio Entrepreneurs. I'm Jonathan Friedman, joined in the studio today by our friend Mark Furman. Mark, how are you this morning?
Great. Jonathan, how are you?
You see, the days go so fast, I don't even realize that it's evening already.
That's right.
I'm well, thanks. It's good to have you on as always. And today you have another interesting topic for our listeners. Mark being our business litigation reporter, giving insight to the world of litigation that he lives within each day.
So I have a non-competition, non-solicitation, confidentiality case that has an interesting twist and I think an unusual result. Pegasystems is a software company, and they employed a gentleman named Mark Manning, who signed a standards letter that talked about a limited non-compete, prohibited solicitation of employees, and also a non-disclosure of certain information. So that was back in 2005. He continued to work for Pegasystems until January of 2014. However, in December 2013, he accepted an offer to become CEO of a company called HealthX. So he notified Pegasystems that he was resigning. His last day was January 31. And then on February 6, HealthX publicly announced that Mr. Manning was joining the company as CEO and president. The next day, Pegasystems sent a letter to Manning and HealthX, according to this counterclaim, falsely accusing Manning of violating the terms of this standards letter that he had signed back when he went to work for Pegasystems.
Yeah, presumably Manning was a senior executive at Pegasystems?
Yeah, it's he was hired originally as Director of Healthcare Services. His responsibilities and compensation materially changed on multiple occasions, but at no time did any of these employment changes result in the execution of a new standards letter. The question is, when do things you do before you go to litigation result in an absolute privilege? I mean, here you have Mr. Manning loses his new position as a result of what he alleges in the counterclaim, in which the court has to assume is true, is a false claim that he violated his restrictive covenant agreement contained in the standards letter. So the court says, in effect, that doesn't matter. You know, we're putting you on notice. We're going to sue you. They then do sue, and between those two events, HealthX withdraws its offer for Manning to be president and CEO. I am very curious to see what happens to this case on appeal, because this is a very common scenario. I represent companies more often than I would the departing employee, certainly. And when somebody's violating a non-compete or some other restrictive covenant, it's very common to send a demand letter to the new employer and to the departed employee. It is then also common to sue both
parties.
So here you have this absolute privilege issue that would insulate someone, at least in the circumstances of this case, if it's upheld on appeal, from any liability for bringing, again, what's described in the counterclaim as a false accusation.